Okay, we're gonna back up a little bit here on the agenda. John was here yesterday. He wanted a comment during our public comment period. There was some confusion over the time for that, so I invited him to come back today and address the board with the short 2 or 3 minutes of public comment period before we take up the regular agenda again. So, John, please come forward.
Yeah, my name is John Scannell. Some of you may know of me. I'm an attorney in the Ninth Circuit, which the bar and the state claimed to have disbarred about 10 years ago, which the Ninth Circuit doesn't recognize. I represent a number of my clients before the Ninth Circuit involving bar issues. And the reason I'm here today, and I'll try to keep this as brief as possible, is that I first started coming to these meetings last December, and it was primarily because the Bar Association appeared to be making a move to try to control its litigation. And to a certain extent, they did. There was the removal of the old director of the ODC, but then instead of following up on the resolution, which is in December, it seemed to me that the Bar Association started becoming more consumed about the fact of whether the Bar Association was going to survive and what was going to happen regarding Sherman Antitrust and Janus. I did attempt to, in that regard, I did attempt to attend some meetings of the WSBA Structures Work Group, and I was never really able to have any input, although they finally did publish a letter that I did to the bar. But the structures of the meetings, in my view, were totally biased. There was no input from the public at all, no public presentations from the public, and it looked to me like the speakers that were chosen were almost entirely picked to put forth the agenda of those that believe that the Bar Association should be mandatory. And it was so much to that extent that I really questioned, and I will be questioning, whether a Supreme Court justice should have even been at that meeting. A few years back, Justice Saunders was sanctioned for attempting to attend prisoners that may be involved in potential litigation and getting a one-sided view. And as far as I'm concerned, that's what was going on. I don't want to belabor that, but the one point that I did want to make out of all that is, in my view, post-Janus, this is going to be a voluntary organization. And what you should be planning for is, instead of trying to defend against a hopeless legal position, you should be doing like the unions, which is making people want to join the unions. Now, post-Janus, the public unions took a hit, but the people that were in the unions to begin with, the people that were not the protesters, not the people that wanted out anyway, less than 0.1% of those people quit the unions. And if you really want to be successful post-Janus, you have to make it clear that if you become a voluntary organization, you want to give reasons as to why the attorneys should continue on. Now, the last comment that I have to make has to do with the original proposals that you discussed last December, which is taking control of the litigation. Now, in our view, there's been this facade that you seem to be, some of the members of the Board of Government seem to be buying into, that ODC has to be kept politically neutral, and that the Supreme Court shouldn't be touching them, the Board of Governors shouldn't be settling their lawsuits or whatever. And it's a facade, because what's happened here, in our view, we haven't been asleep. We've been engaged in a large amount of public disclosure. And what we've discovered is, because no one's controlling it, they become under the political influence of the AG's office. we've obtained we've obtained emails that show that the AG's office communicates directly with ODCs, orders certain attorneys discipline. They're not going through the rest of the procedures like the rest of us do, where we go to Felice Congleton and she dismisses 96% of the grievances. So to continue this idea that that ODC is acting in a political vacuum is nonsense. So I'm here today to finish this up, is that you can start today. You can take control of your own litigation. You know what Sherman antitrust is. Why should you allow yourselves to be dragged into this stuff? The AG's office is up to it in its neck. We have them on it. You have a responsibility to your members, and that is to control the litigation so that their interests are served. So that's about all I've got to say, is that I think that you should continue the process that you began last December, and that is to control your own litigation. Thank you.
All right, thanks, John. We appreciate your comments and appreciate you coming back to share those thoughts with us.